All right. Well, nothing is working right now, but I would like to call this meeting to order of the Senate Judiciary Committee and ask the Secretary to please take the roll.
Vice Chair Cannizzaro.
Here.
Senator Orenshaw. Senator Harris.
Here.
Senator Settlemeyer. Here. Senator Hansen.
Here.
Senator Pickard.
Here.
Chair Scheibel.
Sorry, I am here. I also thought I saw Senator Orenshaw's assistant on the Zoom. So when he is here, either in Zoom or in person, if the Secretary would please mark him present, I will try to let you know when that is. We have 3 bills up for hearing today. We will now open the hearing on AB 23. And our presenter, I believe, is Dr. Neighbors via Zoom.
Thank you, Chair Scheibel. For the record, good afternoon, Chair Scheibel and members of the committee. For the record, my name is Elizabeth Neighbors, and I am here on behalf of the Division of Public and Behavioral Health as the statewide forensic director to present in support of AB 23. AB 23 modifies the time frame for comprehensive risk assessments requested by the prosecutor in criminal cases under Nevada Revised Statute 178.461, subsection 2. And just as a little background to that, Nevada Revised Statute 178.461 allows for an individual who is incompetent without probability of attaining competence and who is charged with a Category A felony and a limited list of Category B felonies to be committed to the Division of Public and Behavioral Health for up to 10 years if they are considered too dangerous for commitment to the civil system. Sorry, I'm losing my notes here. Too dangerous to be committed to the civil system. This comprehensive risk assessment, once a person has been found incompetent, provides information to the court to assist in making this decision, which is obviously a pretty weighty decision for the lengthy time that the person can be committed. In all cases where the charge is other than murder or sexual assault, the recommendation of the evaluator is binding to the court. So the evaluations must be thorough and utilize all evidence-based practices available. They are time-consuming and labor-intensive. The current law allows only 7 days to complete these assessments, and that's in light of that once the request is made by the prosecutor, the hearing has to occur within 10 days, and the report needs to be there 3 days before the hearing. So that leaves only 7 days for that to be completed. And one has to consider that these evaluators have a myriad of other obligations and demands that they're also working with at the same time. So in the years that we have been doing these evaluations, the evaluators have found that this time frame is painfully inadequate to do the kind of job that needs to be done for such a weighty decision. And so this has resulted in repeated requests for extensions to the court, pretty much consistently with almost all of them that we have to complete. And so we are trying to make the timeframes with this bill more reasonable and to allow the evaluators to do the really responsible assessment that they would that they need to do in the face of this request. So we've had some considerable discussion with all of the individuals, the stakeholders involved in this process, and concluded that a 40 calendar day timeframe would meet that need, and with the possibility that there could be an extension if the court deemed it appropriate. And we appreciated all of the input from the stakeholders in helping us come to this language that seemed to be agreeable to everyone. And we are hoping for the support of the committee, and I am happy to answer any questions.
Thank you so much. Do we have questions from members of the committee? Senator Pickard.
Thank you, Madam Chair. Just and thank you, Dr. Neighbors. That was helpful. I'm not a criminal lawyer, but this seems to be aligned with what is currently in practice, except for the time. Is there anything else in this bill that changes the procedure other than the timing in any material respect?
I'm afraid we can't hear you.
You're on mute.
Sorry, it does that without my knowing. You hear me all right now?
Yes, we can. Thanks.
Oh, okay, thank you. Through you, Chair, to Senator Pickard. No, it doesn't change anything except the time frame. The time frame enhances us being able to follow national standards in completing what would be an acceptable comprehensive risk assessment. They involve a number of standardized instruments and requirements for data collection that is very time consuming. So it really helps us meet those standards that are expected nationally for these types of reports.
Thank you. And I've been part of those conversations when we've dealt with the risk assessments and their improvements over the years. So that's perfect. Thank you very much.
All right.
You're welcome.
Other questions from the committee? All right. Then we will move on to testimony in support of AB 23. Sorry, I don't see anybody. Yes, thank you, Mr. Kyle. There's no one present here today to give testimony in any position on any bill, and I will let everybody know if that changes.
Thank you so much, Chair Scheibel. Appreciate that. To testify in support on Assembly Bill 23, please press *9 now to take your place in the queue. Once again, to testify in support on AB 23, press *9 now to take your place in the queue. Caller with the last three digits, 611, please slowly state and spell your name for the record. You will have 2 minutes to speak and may begin.
Good afternoon, Chair Scheibel and members of the Senate Judiciary Committee. This is John Piro from the Clark County Public Defender's Office. We'd like to testify in support of this bill. We'd like to thank Dr. Neighbors and her staff for taking a long time to explain all of these things to us and help us work out solutions that worked for all of the stakeholders involved. We are grateful for their willingness to work with us, hear us out, teach us about the process, and craft a bill that we think meets all of those needs and makes the system better. Thank you.
Thank you, caller. Caller with the last three digits, 318, please slowly state and spell your name for the record. You will have 2 minutes to speak and may begin.
Good afternoon, Chair Scheibel and members of the Senate Judiciary Committee. This is Kendra Birchie, BERTSCHY with the Washoe County Public Defender's Office. I also would like to thank Dr. Neighbors as well as her staff for speaking with us on several different occasions regarding this bill for the timing. As indicated, we do understand that these are very comprehensive risk assessments and they need to have additional time than the normal guidelines set forth for other evaluations. However, on the same time, our clients need to have consistency, especially for this subset of individuals who do have additional challenges, that it's very important to have a specific time frame set in place. And we believe that this strikes the appropriate balance to ensure that our clients aren't languishing in custody, but also that the court has the information that it needs in order to proceed appropriately. We agree with the time frame set forth and believe that it will also provide for judicial efficiency so that we're not continuously going into court for hearings because an evaluation has not been completed. So we appreciate this bill and thank the sponsors for working with us. Thank you.
Thank you, caller. And as a reminder, if you've recently joined us, we're currently on support testimony for Assembly Bill 23. If you'd like to provide support testimony at this time, please press *9 now to take your place in the queue. Caller with the last three digits 080, please slowly state and spell your name for the record. You will have 2 minutes to speak and may begin.
Hi, Jim Hoffman, Nevada Attorneys for Criminal Justice. NACJ supports AB 23. Our ideal preference would be to keep the 7 days deadline that's currently in statute. But in a practical sense, we understand that this takes a lot of work from the division, and with their current level of funding, it's simply not practical to do it on such a short turnaround. So on the assumption that the legislature is not going to find any new sources of funding, 40 days is an acceptable compromise with us. I'd also like to echo the previous testimony. We appreciate Dr. Neighbors and her staff for working with us. There were some extensive discussions, and we support this bill. Thank you.
Thank you, caller. And with that, Chair Scheibel, there are no more callers to give support testimony at this time.
All right, thank you. We will move now to testimony in opposition to AB 23.
Thank you, Chair. To testify in opposition on Assembly Bill 23, please press *9 now to take your place in the queue. Once again, to testify in opposition on Assembly Bill 23, please press *9 now to take your place in the queue. And Chair, at this time, there are no callers to provide opposition testimony.
Thank you, Mr. Kyle. We will move to testimony in neutral on AB 23.
Thank you, Chair. To testify in neutral on Assembly Bill 23, please press *9 now to take your place in the queue. Once again, to testify in neutral on Assembly Bill 23, please press *9 now to take your place in the queue. And Chair, at this time, there are no callers to give neutral testimony.
All right, thank you so much. We will now close the hearing on AB 23 and open the hearing on AB 25. Oh, I'm sorry, Dr. Neighbors, it looks like we can't hear you again. The robots have taken over.
Yes, I'll try and
Now we can hear
be
you.
more attentive. Okay.
Thank you.
Okay. For the record, again, my name is Elizabeth Neighbors, Elizabeth, capital Neighbors. And I am the statewide forensic director for the Division of Public and Behavioral Health, and I am here today to testify in support of AB 25, which is, again, kind of an extension of our management of our folks who are committed under NRS 178.461. So AB 25 changes several aspects of the procedures when returning an individual back to a forensic facility who has violated the conditions of their release under NRS 178.464. And just to go back a little bit in this statute, NRS 178.461 allows, as I have said before, for the long-term commitment of incompetent, unrestorable, and dangerous individuals to a forensic facility for up to 10 years. The individual may, when they have been committed under that statute, petition annually for conditional release from the facility if they have recovered through treatment to the degree that the court considers them safe for supervised placement in the community. And I might comment, they can petition annually. Actually, the division can also petition for them at any time that they think that's appropriate. The process of placement in the community includes a carefully crafted treatment plan and very specific conditions of release that are approved by and overseen by the court that has committed them. They remain in the court of criminal venue when they are committed under this statute. They continue under the supervision which is carried out by the forensic facility. We have staff to do that in a structured setting in the community. So what this bill addresses is the circumstance where that person who's been committed may have a mental health crisis in the placement, and that the individual is in a situation where there is probable cause to believe that they are an imminent danger to self or others, and that they have violated the conditions of their release. In this situation, currently, we have to notify the court and go through a process of speaking with the individuals involved in the case in order to get a court order to return them to the forensic facility. The bill would allow us to respond to the crisis without going through this process of getting a court order and avoid that delay in responding to the crisis. It also allows for the forensic facility to request assistance from law enforcement when we're responding to one of these crises, if the situation appears that would be necessary to preserve safety for all the parties involved. And the third aspect of the bill addresses when the person is returned to the facility, then within 3 days, there needs to be a court hearing to determine whether the conditional release will continue, be suspended, or be revoked. The current statute allows for 10 days. So this would shorten that time frame, and in the face of the fact that there's a court order, that seemed to be very appropriate. However, given the complexities of docketing hearings, it may be, with the agreement of all the parties, extended up to 10 days. So really the goal of this bill is to improve the safety of this process and respond quickly if there should be an incident with an individual that we have placed in the community. We hope we've done a good enough job that won't happen, but nonetheless, these kinds of events do occur, and we need to be able to respond quickly to them. And this would allow us to do that and to have some assistance if we need it from law enforcement when it's appropriate. And we've also had a very good experience with speaking with all the stakeholders to craft the language. With this, we did do some amendments that everyone was agreeable to, and we appreciate the time and effort that everyone put into reaching the final product that we have here. And we appreciate the committee considering this, hopefully in support today. And again, I am happy to answer any questions that you have about this procedure.
Thank you. Are there any questions from members of the committee? Senator Orenshaw.
Thank you very much, Chair, and Dr. Neighbors, thank you for joining us. I guess my question is, just currently under the present statutory framework, have there been difficulties when someone you're supervising has a crisis, and what, just trying to understand why you need this change in the law? What have been the difficulties you've encountered with the current system of notifying the court? And
Chair Scheibel, through you to Senator Orenshaw. We don't have a lot of, these are not large numbers, obviously. The population who are placed in the community come from a very small pool of people, so we don't have large numbers. But yes, we have had some situations where we had to, under very pressured circumstances, try and get the order to bring a person back who was being violent in a facility and where there was a risk of injury to staff or peers. If you would like more information about any of those kinds of events, I'd be happy to get them for you. But that was our concern in changing this. And one of the things that we did was then to have to incorporate all of this into the orders that we get from the court each time we place somebody is one way to accommodate for this. But it would be preferable if it was in the statute so that it was clear and everyone was following the same rules.
thank you, Dr. Neighbors. Thank you, Chair Scheibel.
Any other questions? All right. I don't see any, so we will move to testimony in support of AB 25. Again, there's nobody in the room, so we'll go straight to the phone lines.
Thank you, Chair Scheibel. To testify in support on Assembly Bill 25, please press star 9 now to take your place in the queue. Once again, to testify in support on Assembly Bill 25, please press star 9 now to take your place in the queue. Caller with the last 3 digits, 611, please slowly state and spell your name for the record. You will have 2 minutes to speak and may begin.
Good afternoon, Chair Scheibel and members of the Senate Judiciary Committee. This is John Pirro from the Clark County Public Defender's Office. And again, we'd like to thank Dr. Neighbors for bringing this measure forward, hearing our concerns, and working with all interested parties to bring forward the best bill possible. We are in support. Thank you.
Thank you, caller. Caller with the last 3 digits, 080, please slowly state and spell your name for the record. You will have 2 minutes to speak and may begin.
Hi, Jim Hoffman, representing NACJ. NACJ supports AB 25. The bill as amended does a good job of balancing the practical needs of the division with the constitutional rights of defendants. Again, I would like to thank Dr. Neighbors and her staff for working on this and note our support. Thank you.
Thank you, caller. Caller with the last 3 digits, 318, please slowly state and spell your name for the record. You will have 2 minutes to speak and may begin.
Good afternoon, Chair Scheibel and members of the committee. This is Kendra Birchie, BERTSCHY with the Washoe County Public Defender's Office. I want to echo our support and appreciation for Dr. Neighbors and her staff for discussing our concerns and addressing them with the amended version of this bill. I would just add that in our conversations that this really only applies to less than 20 individuals. So I just wanted to make sure that the committee had that information with the small population that we are dealing with. Additionally, the way that to answer Senator Orenshaw's question, the way that this is currently handled in practice is a lot of the times our clients will end up back at the Washoe County Jail or back in custody. We believe that this will help aid to facilitate getting the individual directly to the treatment center, which recognizes the fact that a mental health crisis is a public health crisis and not a police matter. So we really appreciate this bill and urge your support. Thank you.
Thank you, caller. And as a reminder, if you've recently joined us, we're currently on support testimony for Assembly Bill 25. If you'd like to provide support to testimony at this time, please press star 9 now to take your place in the queue. And Chair, at this time, there are no more callers to give support testimony.
All right, thank you. We will move then to testimony in opposition to AB 25.
Thank you, Chair. To testify in opposition on Assembly Bill 25, please press star 9 now to take your place in the queue. Once again, to testify in opposition on Assembly Bill 25, please press star 9 now to take your place in the queue. And Chair, at this time, there are no callers to provide opposition testimony.
All right, thank you. We will now move to testimony in neutral on AB 25.
Thank you, Chair. To testify in neutral on Assembly Bill 25, please press star 9 now to take your place in the queue. Once again, to testify in neutral on Assembly Bill 25, please press star 9 now to take your place in the queue. And Chair Scheibel, at this time, there are no callers to provide neutral testimony.
All right. Then I will go ahead and close the hearing on AB 25, and we will open the hearing on AB 406. I understand we have Kimberly Smalley with us via Zoom to present this bill, but now I see on the screen someone with the name Kathy Kaplan. I'll let you explain this to us. Thank you.
Okay. Good afternoon, Chair Scheibel and members of the committee. I'm Kathy Kaplan, the Chief of Child Support Enforcement with the Division of Welfare and Supportive Services. I will be presenting AB 406 today with Amendment 326. Also on the call is Candace McDaniel. She is our Deputy Administrator over Field Operations for the Division of Welfare and Supportive Services. Is it okay for me to continue, or does that clear up your question?
Please go ahead with the presentation whenever you are ready.
Thank you. So the Nevada Child Support Enforcement Program has over 83,500 open child support cases. Of those cases, there are over 68,000 with obligors who are in arrears with their child support obligation. Existing statute allows for the withholding for support for a child from any money due an obligor as a judgment, a settlement, or the prize from any contest or lottery. AB 406, as amended, seeks the authority to provide gambling winnings as a qualifying source of money from which to be withheld, whether payable periodically or in a lump sum. Gambling winnings are to be defined as winnings at a licensed gaming establishment, which are required to be reported to the Internal Revenue Service on Form W-2G. Additional collections from gambling winnings distributed to custodial parents will increase the self-sufficiency of children and families while reducing the burden on state resources in the form of public assistance programs. As with other enforcement tools utilized by the program, procedural due justice will be applied and obligors will be provided with the opportunity to contest the withholding. That concludes my testimony, and I'm happy to answer any question the committee may have.
All right. Senator Harris, go ahead.
Thank you so much, Chair Scheibel. My question relates to how much we anticipate this bringing in, given that I know we have locals who participate in gambling at a lot of our casinos, but tourism is really the key here. And so I'm imagining most winners of large pots of money are from out of state, and we don't really have jurisdiction to collect that. So could you talk a little bit about how much additional child support you anticipate this being able to recover?
Thank you for the question, Kathy Kaplan, for the record. At this time, we don't have a projection of what it would look like. The bill with the amendment is just giving us the ability to give a withholding to a gaming establishment if we're aware of the gambling winning. So it's hard to predict how many gaming institutions would let us know of a big payout.
Thank you so much, Ms. Kaplan, and I would just encourage you to maybe reach out to the Gaming Control Board. Maybe there's some regulations we can get in place to require that reporting to you all.
Thank you.
Other questions? Senator Orenshaw.
Thank you, Chair Scheibel. And I think my question's in line with Senator Harris's. I was just wondering if this passes, and let's say a custodial parent informs your office that the other parent who's arrears in child support, let's say, regularly goes to a certain establishment or is part of the players club, to win prizes the more they play, would you be able to just submit that order to that casino and just try to make sure that when there are winnings, whether they're $100 or $5,000, that portion could be deducted for the arrears child support? Or do you think that would work? Or do you think there need to be regulation from the Gaming Commission or Gaming Control Board? I just wondered how you see implementing this to make it most effective, because it seems like a great idea. I just would like to see it implemented effectively.
Kathy Kaplan, for the record. Thank you for the question. For the next couple of years, we plan on working with our stakeholders to try to implement this process to make it more effective. This just kind of lays the foundation that if we are aware that there is a big payout to somebody, we could get that income withholding order in place. Hopefully, the timing would be great, and we would be able to take a portion of that winnings. And we're trying to follow what the Internal Revenue Service would follow when somebody would need to file a W-2G form.
Thank you, Ms. Kaplan. Thank you, Chair.
Any other questions on this bill? Not seeing any, we will move to testimony in support of AB 406. There's still nobody present in the room to give testimony, so we will go directly to the phones. Please, Mr. Kyle.
Thank you, Chair Scheibel. To testify in support on Assembly Bill 406, please press star 9 now to take your place in the queue. Once again, to testify in support on Assembly Bill 406, please press star 9 now to take your place in the queue. Caller with the last 3 digits, 377, please slowly state and spell your name for the record. You will have 2 minutes to speak and may begin.
Good afternoon. My name is Deshaun Jackson, DASHUN, I serve as the Director of Children's Safety and Welfare Policy for the Children's Advocacy Alliance. The Alliance stands in support of Assembly Bill 406. Thank you so much.
Thank you, caller. Caller with the last 3 digits, 200. Please slowly state and spell your name for the record. You will have 2 minutes to speak and may begin.
Thank you, Chair Scheibel and members of the Senate Judiciary. This is Kimberly Surratt, Surratt. I am an unpaid lobbyist and the current president for the Nevada Justice Association. I'm also a private family law attorney in Reno, Nevada, and we are in support of this bill. Thank you.
Thank you, caller. Caller with the last 3 digits, 389. Please slowly state and spell your name for the record. You will have 2 minutes to speak and may begin.
Good afternoon, Chair Scheibel, members of the Senate Judiciary Committee. My name is Jennifer Noble, Jennifer Noble, and I'm testifying today on behalf of the Nevada District Attorneys Association. We are in full support of Assembly Bill 406. Thank you.
Thank you, caller. And with that, Chair Scheibel, there are no more callers to provide support testimony at this time.
Thank you. Next, we will move to testimony in opposition to AB 406.
Thank you, Chair. The phone lines are open and working. However, there are no callers at this time.
All right, we will go to testimony in neutral on AB 406.
Thank you, Chair. The phone lines are still open and working. However, there are no callers to provide neutral testimony at this time.
Thank you, Mr. Kyle. And with that, I will now close the hearing on AB 406. Thank you to our presenters for joining us and presenting the bill and answering the questions. I would also like to thank those people who called in and testified and demonstrated with excellent skill how you can use far less than 2 minutes to make your point. And with that, we will move to the last item on our agenda, which is public comment. Mr. Kyle, is there anybody wishing to give public comment?
Thank you, Chair Scheibel. We are currently on public comment this afternoon. If you'd like to provide public comment, please press *9 now to take your place in the queue. Once again, to provide public comment this afternoon, please press *9 now to take your place in the queue. And Chair Scheibel, the phone lines are still open and working. However, there are no callers at this time.
All right, thank you so much. Thank you, everybody, for being here on Friday afternoon. That concludes our meeting. We will be meeting again on Monday at 1 p.m. Until that time, we are adjourned.